Hey guys. Okay, I'm finally able to get to the order in the Lively fee case, and it is going to be the last thing I read in Lively v Wayfarer, which is, I don't know, it tugs at the heart a little bit because we've been here for so long now. And I know this case probably better than I know my kids, which is something. Um, this has been an interesting read. I have skimmed it. Um, so I'm going to go through it. As usual, give my rants or my opinion. Um, I've got another video coming as well, by the way, because we've got a response from Lively. Because if you remember correctly, in Texas case, Jed Wallace wanted Lively to either sit for another deposition or be allowed to upload her deposition transcript from last year. So Lively has currently, as where we are now, is Lively's responded to the request for another deposition. She has now filed a very brief additional response to the request to upload her deposition transcript. So I will do that later. It is literally only 5 or 6 pages long, so really brief. But anyway, let's do this first. And before anyone says, yes, I know I still have to get to Sarah's motion to dismiss. It really isn't much different. It's almost identical, in fact, to the first one. So I'm wondering. No, do you know what? I said I'll do it. I'll do it. Yeah, I'll do it. Okay. But let's do this one first. Okay. Let's try and make that a bit bigger. Okay, these two cases, the Lively action and the related action, the Wayfarer action, involve the film It Ends With Us, and the contentious fallout between the film's two co-stars, Blake Lively and Justin Baldoni. Contentious fallout. That's an interesting way to describe a sexual harassment situation. Blake Lively, who was defendant in the Wayfarer action, now moves for an award of attorney's fees and costs pursuant to California Civil Code, Section 47.1. For the following reasons, the motion is granted in part and denied in part. And to be fair, I think we all had money on the fact that he would grant in part and deny in part. Okay, background and procedural history. This court has previously outlined the background of this dispute at length. Haven't we all? Familiarity with the prior proceedings is presumed. Lively and Baldoni have waged a fierce battle against each other in court. Lively initiated the legal dispute by filing an administrative complaint before California Civil Rights Department on December 20th, 2024, accusing Baldoni and his co-defendants, collectively the Wayfarer parties, of sexual harassment and retaliation in connection with the conduct on the set of the film and related to the marketing of the film. Lively followed that administrative complaint with a lawsuit filed in this court on December 31st, 2024, levelling charges of sexual harassment, retaliation, breach of contract, intentional infliction of emotional distress, negligent infliction of emotional distress, and false light invasion of privacy against Baldoni and other Wayfarer parties. And I will just add, I know Liman is sticking here to the court proceedings, the legal proceedings, but technically she followed the administrative complaint with a, front page, 4,000 word, kind of story in the New York Times. The Wayfarer parties responded several weeks later with a lawsuit against Lively and her husband, Ryan Reynolds, as well as her publicist, Leslie Sloan, and Vision PR. The complaint in the Wayfarer action contained causes of action for civil extortion, defamation, false light invasion of privacy, breach of the implied covenant of good faith and fair dealing, intentional interference with contractual relations, intentional interference with prospective economic advantage, and negligent interference with prospective economic advantage. Is my voice going already? I think my voice is, my voice is cracking. Great. On January 31st, 2025, The Wayfarer parties filed their first amended complaint. It added claims against the New York Times Company for defamation, false light invasion of privacy, promissory fraud, and breach of an implied in fact contract. Otherwise, it contained the same causes of action against Lively, Reynolds, Sloan, and Vision PR. On June 9th, 2025, the court granted the motion of Lively and the other defendants to dismiss the First Amendment complaint in the Wayfarer action, giving the Wayfarer parties leave only to amend their tortious interference with contract and breach of implied covenant claims by June 23rd, 2025. The Wayfarer parties did not file a further amended complaint. On September 8th, 2025, Lively moved for attorney's fees, treble damages, and punitive damages under California Civil Code Section 47.1. By opinion and order of June 12, 2026, the court determined that Lively was entitled to her attorney's fees and costs pursuant to California Civil Code Section 47.1 in connection with the lawsuit alleging inter alia claims of defamation against her. In that same opinion and order, the court determined that she was not entitled to compensatory or punitive damages. The court ordered Lively and the Wayfarer parties to submit papers regarding the appropriate measure of fees. Lively now seeks $8,035,040.88 in fees and costs, including $7,495,526.87 in attorney's fees and costs in the amount of $539,514.01. The Wayfarer parties argue that Lively's request is so inflated that the court should deny it altogether, and that at minimum the court should substantially reduce Lively's request using as benchmark the $181,622.70 the New York Times sought in related litigation as fees and costs for defending against a related claim brought against it for defamation. The scope of Lively's entitlement to fees. The parties spar at the outset on the reasonable fees and costs for which Lively is entitled to reimbursement. Lively claims that she is entitled to reimbursement for all of the attorney's fees and costs she incurred in the litigation in which the defamation claim was asserted, including the fees and costs incurred in furtherance of that recovery. To that end, Lively seeks reimbursement both for all of the fees incurred on the motion to dismiss the First Amendment complaint in the Wayfarer action, but also all work associated and intertwined with the Lively action until June 23rd, 2025, the date by which the Wayfarer parties could amend the First Amendment complaint. The Wayfarer parties claim that Lively is entitled only to the reasonable fees and costs necessary to defend against the defamation action. The Wayfarer parties have the better of the argument. Jesus, I never thought I'd see Liman write those words. But clearly they did. It was blatantly obvious. California courts look, in the first instance, to the words of a statute in construing its meaning. If the language permits more than one reasonable interpretation, however, the court looks to a variety of extrinsic aids, including the ostensible objects to be achieved, the evils to be remedied, the legislative history, the public policy, contemporaneous administrative construction, and the statutory scheme of which the statute is a part. The language of California Civil Code Section 47.1 is ambiguous. I didn't think it was. I think a lot of, especially the legal content creators, did not think it was. I think even the non-legal content creators did not think it was, and many of our little channel community did not think it was ambiguous. So it provides that a prevailing defendant in any defamation action brought against that defendant for making a communication without malice that is privilege under this section shall be entitled to their reasonable attorney's fees and costs for successfully defending themselves in the litigation. The statute does not speak directly to whether the litigation refers to that portion of the case that contains claims for defamation or whether it extends to the entire litigation. That is fair, but common sense, including unrelated claims against the defendant. An examination of the evils to which California legislature addressed itself in California Civil Code Section 47.1, as well as considerations of public policy, suggest that the defendant is entitled to reimbursement only for those fees and costs incurred in defending against the defamation claim. As the court previously observed in passing Section 47.1, the California legislature intended to provide a measure of protection for the speech uttered by victims of sexual assault. The law begins with a declaration that a communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination is privileged under Section 47. The California legislature intended to deter a form of slap lawsuit, which the legislator found was increasingly being used as a weapon to threaten, silence, intimidate, and dissuade survivors of sexual assault, harassment, and discrimination from speaking out against their abusers and exposing predators. It also intended to help take the burden off survivors by providing reasonable attorney's fees and damages if they successfully defend themselves against meritless lawsuits. There is nothing in the law or in the legislative history that indicates that the California legislature intended to award a defendant accused of a range of tortious conduct other than a slap lawsuit all of her fees and costs in defending against that conduct simply because the person who is the target of that conduct has included in his or her lawsuit a claim for defamation. The facts of this case illustrate the point. Defamation was one of many complaints made by the Wayfarer parties against Lively, her husband, and her publicist. The Wayfarer parties also alleged that Lively engaged in civil extortion in violation of California law when she, 1. refused to return to production unless the Wayfarer parties agreed to her return to production demands, 2. threatened to abandon her contractual obligation to promote the film or approve marketing materials unless the Wayfarer parties agreed to co-fund a screening of her version of the film, eventually release that version and grant her a producer credit and support in seeking the PGA designation licensed by the Producers Guild of America. I'm really glad he's just recapping on all of Lively's, crimes here. 3. threatened to boycott the premiere unless Baldoni was excluded, and 4. threatened to attack Wayfarer in the press if it did not take the blame for problems during filming. The Wayfarer parties also alleged that Lively breached the implied covenant of good faith and fair dealing in the contract by which Lively agreed to perform as an actor in the film It Ends With Us by making threats, seizing creative control, and depriving the Wayfarer parties of the opportunity to produce, edit, and market a film as contemplated by the contract. They further alleged that Lively, with Reynolds, intentionally interfered with Baldoni's relationship with his talent agency by making threats to it to drop Baldoni. Again, we've seen all the evidence now. The evidence is all out. So, Liman dismissed all these claims before he saw the evidence. We've now all seen the evidence. A lot of it was attached to the motion to dismiss and motion for judgment on the pleadings. Liman will be aware of this evidence now. So he seems to be where his June 9th order dismissing Wayfarer's claim was, well, it could have been hard bargaining, in reference to Lively's extortion demands. We've actually seen evidence it wasn't hard bargaining. It was pure unadulterated blackmail. So now you can hear the kind of certainty in his tone and his word in here, like, well, Lively did this and Lively did that. And I'm absolutely loving that this is going on to a public docket. And there no longer seems to be any kind of, doubt. The court dismissed the civil extortion claim only after an extended discussion in which it took issue with a decision by a federal district court in California. It dismissed the claims for a breach of the implied covenant and intentional interference with contract without prejudice. Those claims were not pursued only because Baldoni decided not to pursue them. Lively has given no reason why she should be entitled to her fees and costs in defending against each of those claims simply because the Wayfarer parties also chose to sue her on a claim that she was making false allegations of sexual harassment against them. Nor has she provided any reason why she's entitled to any attorney's fees or costs after June 9th, 2025, the date when the court dismissed the Wayfarer party's defamation claim with prejudice. Okay. The federal rules allow a plaintiff to state in one complaint as many separate claims as it has. The rules thus contemplate an expansive definition of case, including all claims that the party has against a particular opponent falling within a federal jurisdiction. If Lively's interpretation of the litigation in Section 47.1 were adopted, it could not be limited to claims that related to the defamation claim. It would extend to all fees and costs incurred in the entire litigation, regardless whether the claims had any relation to the defamation claim. Exactly, it would have been completely absurd. Such an interpretation would extend far beyond the goals that the California legislature was intending to accomplish in enacting Section 47.1. This conclusion is consistent with California law. The California courts have held that when a cause of action for which attorney's fees are provided by statute is joined with other causes of action for which attorney's fees are not permitted, the prevailing party may recover only on the statutory cause of action. There is no reason to believe that California courts would apply a different interpretation to California Civil Code Section 47.1. Lively's reasonable attorney's fees. This was by far the most entertaining part of this order. Lively seeks $8,035,040.88 in fees and costs, comprised of $7,495,526.87 in attorney's fees and costs, and costs in the amount of $539,514.01. Under California law, a trial court assessing attorney's fees begins with the lodestar figure based on a compilation of the time spent and reasonable and hourly compensation of each attorney involved in the case. The court calculates the lodestar by multiplying the number of hours reasonably expended by the reasonable hourly rate prevailing in the community for similar work. Two law firms, Manat and Wilkie, represented Lively in this action. Lively has submitted evidence that her attorneys from Wilkie charged her at rates ranging from $1,551 to $2,795 for the partners assigned to the case, and $1,275 to $1,573 for two of the associates. The median charge for all partners was $1,650, and for all associates was $1,225. Wilkie provided Lively a discount of 15% off its standard hourly rates. The partners from Manat charged Lively discounted fees ranging from a rate of $1,161 to $1,287 and $1,026 to $1,138.50 for the most senior partners, to effective rates of $1,008 to $1,120.50 and $1,044 to $1,161 for the more junior partners. I absolutely hate reading numbers. I've got severe dyscalculia, and I hate reading numbers, and I do hesitate when I'm reading them. And this particular order and the motions for it have so many numbers, makes me uncomfortable. An hourly rate is reasonable when it is within the range of reasonable rates charged by and judicially awarded comparable attorneys for comparable work. Courts consider 1. The experience and qualifications of each attorney and paralegal who billed on the case. 2. Rate determinations in other cases. And 3. Surveys of prevailing rates among similar attorneys. A billing rate that is the usual rate an attorney charges for his or her services is evidence that the rate approximates the market rate. The actual billing arrangement certainly provides a strong indication of what private parties believe is the reasonable fee to be awarded. The fact that a paying client was willing to pay, and in fact paid a certain amount to litigate a case, is strong evidence that the fee was reasonable. At the same time, the prevailing defendant is entitled to reimbursement only for reasonable attorney's fees. The prevailing defendant cannot burden the plaintiff with an exorbitant fee arrangement. Counsel's rates were not unreasonable. This case as a whole presented substantial financial and reputational risks for all parties involved. It also involved complex legal issues. It was extremely well litigated. I'm just digesting that a minute. Okay, so I have a lot of issues with Hudson and Gottlieb and how they ran this case. Like, serious issues. I even think there were some ethical issues and boundaries crossed. But they are able to say they scored a win. Quiet, Mia. They are technically able to say they scored a win for their client, if you can say that. They brought through a case of first impression, a huge statute, California statute for sexual harassment victims. And a case was decided, and reasonable attorney's fees and costs were awarded. Now, given that attorneys can only work with the evidence that's available and provided by their client, and given that there was absolutely no evidence of sexual harassment, I think they'll be happy with the overall outcome that they got. They got a lot of, press bylines as well, which they were able to twist into Lively's favor. Not saying it did any good for her reputation, but they definitely lost the PR battle, I think. I think Friedman absolutely handed them their ass on that, which was his role. Like, if we flip it on its head, and I've said this so many times, is okay, Wayfarer's complaint got thrown out. Okay, they were on the hook for 47.1. But many people did not know who Justin Baldoni was, who Wayfarer were. The world knows who they are now. And many, many people who initially, like just based on Blake Lively's story in the New York Times or her complaint, especially given that at the same time, Stephanie Jones filed a damning complaint as well, which was very public. Kind of saying, well, Wayfarer did this, Baldoni did that. They said they did all these awful things. Like, it was really easy for the public to leap to the conclusion that, they've definitely done it, that, they should be taken down, destroyed, and cancelled, and everything that comes with that. And this man had no real reputation. People didn't know him for much. They knew him for Jane the Virgin. There wasn't that much else. Because even his films are like 5 feet apart and Clouds, he wasn't on the camera. He wasn't in front of it. He was behind it. So, not unless you were like avid Jane the Virgin fan like me, you hadn't really heard of Justin Baldoni. And Brian Friedman has made them, you know, brought the story out, brought the evidence out, and the world literally flipped. It was, even Johnny Depp didn't achieve that, right? Even the most diehard Johnny Depp fans, um, it took them a lot of time. Yeah, it took them the entire trial, by which point, years had gone by. The damage was, it was allowed to set in and rot. And by the time we all saw the trial, I mean, I didn't believe it anyway, but by the time we saw the trial, saw the lack of evidence, saw Amber Heard with her abysmal testimony, um, you know, some people were already too hardwired to the belief that, well, he must have done something, even though he won his trial. And it was a defamation case, obviously. Even though he won that defamation case, and we all learned that Amber Heard did not, in fact, donate her divorce settlement to a children's hospital, etc. Many people had already had a hardwired belief by this point, which they were not prepared to completely change their mind on. And the thing is, this is what was critical. And this is what Friedman did so successfully: is he got straight in there and got the evidence out immediately. He didn't allow people to sit there and, especially with the competing complaints of both Stephanie Jones and Blake Lively and the New York Times article. And then you had all of the celebrities who come out in support of Blake Lively as well. And it was, Friedman did a phenomenal job of getting public opinion back on Baldoni's side in absolute record time. And that was critical to the ongoing support that followed and continued. All the internet sleuths who helped, pull apart Lively's claims and the evidence she did put forward. And as the attorneys themselves said, thank God for the internet sleuths and the mummy sleuths, because they did a lot of work and saved the attorneys a lot of time as well. Even if it was just, finding old videos and interviews of Lively and Reynolds, showing them to be complete pieces of shit, showing them to be doing the stuff they're now saying is terrible, awful, worse than Weinstein. Or what was the name? I can't remember that actor's name. Olivia. Oliver Stone. Well, I want to say so, but like Ryan Reynolds literally saying this is the worst thing I've ever seen, blah 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 blah. And really, no, mate, you done worse. Okay, so that's just my little side thing. Yeah, I mean, in terms of Lively didn't get a complete loss, and she is getting something back, which from a PR perspective, she can score that as a win. Then yeah, her attorneys did litigate this case quite well. Okay, the rates. Sorry, but I will say though, Wayfarer's lawyers did it better. I do think, right? Because let's face it, this was never a legal battle. This was always a PR battle. It started with PR. It ended with PR. The rates are not outside the range of reasonableness in the community for the best lawyers handling highly complicated and high-stakes litigation. Lively seeks attorney's fees for 82 timekeepers, including 53 from Wilkie, which is just fucking ridiculous, and 29 from Manat. But she includes biographical information, title, and billing rate information for only 11 timekeepers. The court has no basis to evaluate the fee request for the remaining timekeepers and therefore denies it. The number of hours for which Lively seeks reimbursement is unreasonable. Yes! We have an admission from Judge Liman that finally Lively is unreasonable. Lively has submitted the declaration of a purported attorney fee expert who has reviewed the billing records. Lively has not submitted the invoices themselves. The analyst claims that the two firms billed $2,267,288.75 for motion practice in the Wayfarer action, including the motion to dismiss, a Rule 11 sanctions motion, and the Section 47.1 motion. And the Rule 11 sanctions motion has shit all to do with a defamation claim. She also claims that the two firms billed her for work associated and intertwined with both actions, including discovery and fact-gathering exercises, in the amount of $5,228,238.12 through June 23, 2025. As an initial matter, Lively is entitled to reimbursement for the reasonable attorney's fees incurred in briefing a portion, but not all, of the motion to dismiss and all of the Section 47.1 motion, which is fair. She is not entitled to reimbursement for any of the cost of Rule 11 motion. Lively filed a 36-page memorandum of law in support of the motion to dismiss, in which she argued that the complaint in the Wayfarer action failed to identify the specific defamatory statements by Lively. Certain statements were outside of the statute of limitations. Lively's statements were protected by a number of privileges under California law, and the first amended complaint failed to allege actual malice. She also filed a 16-page reply memorandum. The costs she incurred for these filings were incurred in the defense of the defamation action. But the category of motion practice is overexpansive and includes work for which Lively is not entitled to an award of attorney's fees. And I'm glad they picked up on this next bit. The two law firms also represented Reynolds, who filed an entirely separate motion to dismiss, supported by a 29-page memorandum of law. Lively is not entitled to reimbursement for the cost of preparing and filing that motion. As to the Rule 11 sanctions motion, and this is the point I made, it was directed to claims asserted by persons other than Baldoni against Lively and Reynolds for civil extortion, defamation, and intentional interference with contract and breach of an implied contract. The motion was directed solely to the defamation claim against Reynolds. It sought no sanctions for the Wayfarer party's defamation claim against Lively. The court granted in part and denied in part the Rule 11 sanctions motion. Importantly, the court denied Lively's request for attorney's fees as a Rule 11 sanction. Lively thus is not entitled to reimbursement for the work on that motion. And so much of that ridiculous spreadsheet with, the I know it was a ridiculous spreadsheet that she tried to use to evidence a 600+ page document. So much of that was Rule 11 sanctions. There was a huge amount that was just for Rule 11 sanctions. Lively is entitled to reasonable attorney's fees for her motion directed to whether she was entitled to fees under Section 47.1. There is no doubt that Lively is entitled to the reimbursement for some of the fact-gathering and discovery processes. And this is going to be the difference between the New York Times and Lively is New York Times weren't engaged in any discovery. They had a stay of discovery, so no one was doing discovery on them, but they also weren't doing discovery on anyone else. Lively did have to do some discovery. So it was a given that even if the starting point was, well, the New York Times requested reimbursement of this amount, there is going to be more for Lively because there is some discovery, and that does encompass the motion to dismiss. That is kind of baked into that. But it shouldn't be much. There is no doubt that Lively is entitled to reimbursement for some of the fact-gathering and discovery processes. Fees need not be apportioned when incurred for representation of an issue common to both a cause of action for which fees are permitted and one for which they are not. All expenses incurred on the common issues qualify for an award. Discovery against Baldoni in the Wayfarer action, unlike discovery against the New York Times, was not stayed. Work devoted to discovery on Lively's sexual harassment claim would have been intertwined with the work necessary to defend against the defamation claim. But but Lively's blunderbuss approach leaves the court no way to determine precisely how many hours were reasonably incurred on common issues. And that's, for high fee charging, high quality, highly experienced attorneys, their timekeeping and recording was absolutely diabolical. So the judge is saying, because of the way they have kept their records, it is impossible to, pull apart what was done for what. The court's got no way of working that out. Moreover, the Wayfarer parties have identified a series of flaws in the record that are illustrative of broader discrepancies and deficiencies in the fees schedule. Where is it? Yeah. First, the billing record contain entries for internal communications that are often vaguely described and do not identify the issues discussed, work performed, or whether the meeting pertained to defending the defamation claim or the broader litigation. Internal communications may represent reasonable collaboration, but where extensive, courts may reduce fee awards for hours billed for internal, inter-office, or intra-office communications or conferences. Yep. Second, the records include entries that are partially redacted, which makes it difficult to determine the full scope of the work performed. For example, one entry bills time to revise legal memo into XX, and another bills time for analyze and revise final draft of legal memo addressing XX. Tells you nothing. In the federal context, a district court has an obligation to deny a fee request where billing records are so heavily redacted that they do not provide sufficient information for the court to judge the reasonableness of the fee request. Relatedly, many entries are vague and render it difficult to determine what work was performed on what motion and in which action. Third, Lively seeks fees for time billed towards media relations, including strategizing media communications and client media appearances. Hours spent for media contacts and press conferences are generally not compensable. Federal courts have found the giving of press conferences and performance of other lobbying and public relations work is solely compensable where it directly and intimately related to the successful representation of a client. That litigation involves reputational interest is insufficient on its own to render media communications intimately related to clients' representation. Media relations were not integral. Media relations were not integral to defending the defamation claim brought against Lively. Accordingly, time spent on media relations and press coverage is not compensable. Fifth, Lively seeks fees for clerical or administrative work that was billed at attorney rates. I don't think even Wayfarer brought this up, if I remember correctly. Judge Liman, fair dues to him, has really gone through all of this with a fine-tooth comb. So what actually happened here is it was simple admin work. Where is it? Yeah, he's given a couple of examples here, actually. Assisted with filing, updated a team case tracker, analysed case dockets, provide updates to litigation team regarding pertinent deadlines. These are things that should have been done by admin and clerical staff, secretaries maybe, assistants, those kind of people. But they were being billed at the attorney rates. And there is, not by any stretch of the imagination would an admin assistant be billing time at the same rate as an attorney. Not even a paralegal, Like an admin assistant would not be billing even at the same rate as a paralegal. So there's just not the knowledge, the experience, the qualifications there to justify it. Okay. Sixth, Lively also seeks fees for travel time, but in some entries does not identify the proceeding or other event related to the defence of the defamation claim that required such travel. Courts will award attorney's fees for travel time so long as the amount of time spent travelling is reasonable and the meeting or event to which the attorney is travelling is necessary to the case. Absent identification of a necessary travel meeting or event, attorney's fees for travel are not warranted. In such circumstances as present here, where the prevailing party has not made any effort to allocate the fees to which the claim on which she prevailed, the California courts will assign a reasonable percentage to the entries or simply cast them aside. The court is also permitted to apply a steep discount where a party has made an outrageously unreasonable demand. If the court were required to award a reasonable fee when an outrageously unreasonable one has been asked for, claimants would be encouraged to make unreasonable demands, knowing that the only unfavorable consequence of such misconduct would be a reduction of their fee to what they should have asked in the first place. To discourage such greed, a severer reaction is needed. The New York Times has asked for reasonable attorney's fees in the amount of $181,622.70 in connection with its defense of the defamation claim arising from the same statements. Lively was reasonably required to incur greater fees, including with respect to discovery and the briefing of the Section 47.1 motion, and I do actually agree with that. That's true. Accordingly, the court awards Lively double the amount sought by the New York Times, or $363,245.40 in attorney's fees. Lively's reasonable costs. Lively's request for litigation costs is governed by Section 1033.5 of the California Code of Civil Procedure. That section provides inter alia that filing and motion fees, deposition fees, service costs, ordinary witness fees, and cost of transcripts, where ordered by the court, are allowable as costs. It also excludes certain categories of litigation expenses from the costs. Right, well, he started with B. Okay. The following items are not allowable as costs except when expressly authorized by law. 1. Fees of experts not ordered by the court. 2. Investigation expenses in preparing the case for trial. 3. Postage, telephone, and photocopying charges except for exhibits. That should include binders. 4. Cost in investigation of jurors or in preparation of voir dire. 5. Transcripts of court proceedings not ordered by the court. It further provides that allowable costs shall be reasonably necessary to the conduct of the litigation rather than merely convenient or beneficial to its preparation, and shall be reasonable in amount, and that items not mentioned in this section and items assessed upon application may be allowed or denied in the court's discretion. Section 47.1 does not expressly authorize costs beyond those allowed under Section 1033.5. Lively's expense analyst provided 3 spreadsheets representing costs incurred by Lively in this action. The spreadsheets include costs for travel, research fees, experts and consultants, office supplies, and filing fees. Among these costs, Lively identifies $173,276.50 in costs charged by GBX Holdings as incurred exclusively for the purpose of assessing the impact to Miss Lively's reputation, if any, from the Wayfarer action in support of the Section 47.1 motion. Time billed to Wilkie by GBX Holdings included time to research and preserve social media posts, news articles, and TV news materials with mention of defamatory content related to the Section 47.1 claim, and time assembling a Section 47.1 report with such information. This report, while related to Lively's Section 47.1 motion, is fairly categorized as an expert report, the cost of which is not recoverable under California law. Lively additionally seeks $134,519.65 in research expenses for Westlaw, LexisNexis, Bloomberg, Pacer, and similar charges. I can't believe she asked for that. The California Court of Appeals has found that legal research falls under the non-recoverable category of investigation expenses pursuant to Section 1033.5b2, as it should be. As to Lively's other expenses, those for travel, meals, office supplies, and discovery services, Section 1033.5 does not expressly allow or prohibit recovery for such costs, and those costs accordingly may be awarded or denied in the court's discretion. These expenses are not explicitly tied to an identified motion, appearance, or aspect of litigation where it is not possible to allocate expenses to specific claims. It is appropriate for the court to award a portion of the total expenses. The court will award costs for $11,721.86 in travel expenses, identifiably tied to court appearances for the pre-trial conference on February 3rd, 2025, and the oral argument on the Section 47.1 motion on June 1st, 2026. The court will further award costs for the $154.80 in transcript filing fees and 1/6 of the expenses for discovery services incurred prior to June 9th, 2025, in the amount of $32,329.69. In sum, the court awards $44,206.35 in costs. Conclusion: Lively's request for attorney's fees and costs is granted in part and denied in part. So there we are. Clerk of the court is respectfully directed to enter judgment for Lively in the amount of $363,245.40 in attorney's fees and $44,206.35 in costs. So there we are. She got next to nothing from her starting point of what she was seeking. She got nothing, really. Absolutely nothing. That's a drop in the ocean for Sarowitz. To be honest, it is for Baldoni too. This is where their wealth really doesn't matter. I still think Wayfarer were the winners. They come out with their reputations largely intact, and in fact are doing better than ever now in public opinion, because so much more of the public knows who they are. So okay, this afternoon this afternoon my time, I will be following up with my video on Lively's response in the Wallace, Texas case.